Hi everyone, it's Karen Cole here from Legal Minded Friends, and today's question is, how can I get legal help? And we're going to answer this by looking at the future of access to justice in the 21st century as it's under review. So the incoming head of Civil Justice and Master of the Rolls just spoke at the CJC National Forum. And if you'd like my take on it, please listen to the next part of the video. Thank you. So let's take a little listen to part of the forum when His Honourable Sir Geoffrey Voss speaks about his vision going forward in 2022.
I want to speak today about what access to justice looks like in the modern world and what might be the components of a civil justice system fit for the 21st century. I've been thinking about these issues quite a lot lately in the run-up to my new job starting at the beginning of the next legal term. And my views on these issues have been formed by essentially three matters. First, civil justice, as I see it, is essentially regional and not, in any sense, London-centric. Secondly, there's a need to consider civil justice from the bottom up rather than the top down, and that is extremely important. And thirdly, I do not think one can reform civil justice without listening to judges, court users, the legal advice sector, and charities operating in the county courts across the country. And as many of you will know, I have for many years been a proponent of the use of new technologies, a proponent of law tech, and even responsible engagement with artificial intelligence and the blockchain in the legal sector. So I want today to look at how these technologies can be employed to improve access to justice in general and access to justice for the vulnerable and those without means in particular. I hope that I will not be viewed by too many of you as a, quote, tech pusher, advocating the, quote, bright, shiny toys that we heard about this morning. As it seems to me, there are essentially three issues that underlie the creation of a genuinely forward-looking dispute resolution system. First, we should understand that justice cannot any longer be delivered according to the tried and tested methods of the 19th century. It will need to be brought online in order to meet the expectations of people of today at all levels of our society, rather than the lawyers of yesterday. And secondly, we should not undertake reform by simply doing digitally what was previously analog. And thirdly, the emphasis should be on the resolution rather than on the dispute. Now, I'll explain in a little more detail the implications of each of these underlying principles. But the starting point is to look at dispute resolution holistically, knowing, as I've said often, that it extends from 60 million disputes on eBay resolved by artificial intelligence every year at the one end, to millions of family disputes about money and children, to many more millions of administrative law disputes between citizens and the state, to a range of disputes concerning employment and housing, ending up with those faced by SMEs and larger commercial entities at the very far end. They are dealt with by a variety of online platforms, ombudsmen, arbitrators, mediators, and sometimes, only sometimes, by courts and tribunals. It is really important to understand the range of cases that is being considered when one is looking for improvements. There is, I think, no reason whatever why there should not be a single point of online entry really for almost every dispute, however large or small, for those with or without legal representation, whether civil, family, business, or administrative. The same basic data set can be created from the outset and used as the resolution process progresses. And next, there should be no assumption that every case will end up in a traditional courtroom, although of course some may. We should not have fixed ideas about the end point, because that impedes the most important part of any such process, which is to bring about mediated or other satisfactory solutions. And mediated interventions should not be at a single point on the journey, but should be an integrated part of the entire process. Parties should be led culturally to expect that the process will be about achieving a resolution rather than about exacerbating or even necessarily always deciding who is right about the dispute that gave rise to the process. So let me return to my three underlying points. The online process. Now, as I see it, an online process available to all for all types of case would have an immediate and positive impact on the availability of the justice system to many more members of our society. A huge percentage of disputes that affect people's lives are not complex or even intractable. Some, of course, are, but we don't want a system that is tailored to the most difficult issues alone. Ultimately, the most difficult disputes will have to be dealt with by judges, working often with the parties' lawyers where they're represented, either online, asynchronously, or at a series of remote hearings arising from the online process, or even in a traditional court. But we need a system, in my view, that allows the very many quite simple disputes to be resolved speedily and effectively without unnecessary cost. And if we can achieve it, it will be transformational. Much time and cost is expended on disputes of the many kinds I've mentioned. They disrupt people's private and business lives. As we've heard this morning, they affect their mental health, and they're damaging to the economy. Allowing citizens speedily to vindicate their legal rights, to be paid what they're owed, to resolve their family issues, and to settle whatever issues are preventing them moving forward with their lives, will be a huge benefit to individuals, consumers, small businesses, and SMEs alike. My vision is for an online funnel into which all the civil disputes, and hopefully in time those in family and tribunals as well, will be directed at the outset. The complex ones may emerge quickly to be dealt with by legacy systems such as the business and property courts or elsewhere, but the simple ones ought to be capable of quick and effective online solutions. So how do we avoid digitizing the existing process? As we've heard this morning, the awful COVID-19 pandemic has meant that many hearings can now take place remotely rather than in person. Now that's a good development, mostly. It's even better that so many parties and lawyers now feel comfortable using remote technologies and electronic documentation. In my view, however, remote hearings are not by themselves a long-term solution, because they just allow us to undertake the same process by a technological method. The rapidly changing circumstances of our modern lives necessitate an entirely new approach to dispute resolution. Those circumstances include the ready availability of the internet to the vast majority, but I understand not all, of our citizens and businesses. The massive accumulation of data, about which we've heard a lot today, affecting every aspect of our working and personal lives, and the availability of smart systems and artificial intelligence that can process that data and assist us in every aspect of our experience. The use of technology will grow, it will not recede. It will increasingly affect almost every aspect of what we do. And once one realizes the kind of society for which dispute resolution is going to be required in the future, it becomes obvious that it would not be sufficient just to put our existing procedures online. Instead, it's necessary over time to develop intelligent systems that can arrive at the issue in an ordinary case far more efficiently. In most cases, the issue in the case is indeed very simple. Was the car going too fast? Did John lend Mary £500? Did Usha pay the rent? Were the mortgage installments due? The objective in all cases must be to identify the real core issues in dispute by the quickest possible route. So I come to the point about it being for resolution rather than dispute. If every case can enter the metaphorical online funnel, it will be possible to apply online mediated interventions more efficiently at every stage in the process. The problem in our current system is that mediation is regarded as a single one-time intervention, when in reality compromise is possible in different cases at different times. An online process would allow more frequent mediated interventions tailored to the particular circumstances of each case. There needs, if possible, to be cultural change. Those with disputes with authorities, with their neighbors, or in their personal and business dealings need to understand that when they enter a dispute resolution process, the objective is to achieve a resolution, not to exacerbate or even always to reach, for the sake of it, a judicial adjudication of that dispute.
So my takeaway is that there will be a focus to provide more online services to access justice, from the start of a dispute to ensuring negotiations and mediations take place to find a resolution prior to going to the courts, and to only use the courts when absolutely necessary. And as we've discovered in previous videos, the courts are accepting online applications more and more. And because of the pandemic, we've had online hearings. So it sounds to me as this will be the way of the future. Legal Minded Friends has always been online focused, with services by telephone, WhatsApp, and email at times to suit you. The forum also includes different speakers who represent agencies or services that are virtual. So please check out the link below, as there is alternative ways to access justice already. Well, I hope you found today's video interesting and useful. And if you have a legal worry and you want to be a litigant in person or understand a little bit more about a legal process, then please contact Legal Minded Friends. See the links below and like and share. You never know who it may help. Thank you.